moving on to guardianship. Parents are usually guardians when they live together, as you know, and then they separate. And the main one that I want to focus on is 39.3c, is a parent can become a guardian when they regularly care for a child. And this is the weird thing in the Act, as you know. If you are a mom giving birth, you don't actually fall under 30, and without your partner living with you, you don't fall into 39.1, right? You're not a guardian because of that, because you're only a guardian if you are living together. The parents are living together at the time the child's born. If you're not living with your partner, you're not a guardian under 39.1. You generally pretty quickly become a guardian under 39.3c, because presumably you're going to regularly care for the child. So this, of course, is like oftentimes it's the other parent who is trying to establish that they have regularly caring for the child, and so therefore are a guardian. Because otherwise, if you're not a guardian under this section, what do you need to do? You need to apply to be a guardian under Section 51, right? And that's a bit more of work. So, what is regular care? And again, there's not sort of any new cases this year I could come across, but one of the older cases from Mr. Justice Punnett in 2013, he noted that the father never lived with the child, and in this case, the father at best saw the son on a weekly basis between end of May 2012 and August 2012. And then there was an interruption in that period, and so the judge says, look, that sort of limited contact can't be characterized as having regular care. And as a result, the father is not presumed to be a guardian, and he has to apply. Now, that's sort of the more extreme sort of, that you'd go, well, that's kind of obvious, right? You see a child once or twice a week, and then you go off for a little bit and you come back. Well, that doesn't mean regular care. So the trickier parts are, though, is this one that Doyle and Hanley from Mr. Justice Armstrong also talks about the willingness to provide for a child's ongoing needs and a record of usually and normally doing so, more than simply visiting a child at regular intervals. So it's not just like, hi, I'm coming to see my child for 2 hours a day for the next little while, but actually taking care of the child's needs, feeding the child, bathing the child, taking the child out, doing things with the child, right? As the child gets older, taking the child to activities, taking the child to school. Sometimes it's overnight, something. That would constitute more actually providing for a child's needs, right? Not just visiting. So there's still not clear case law on how much sort of involvement you have to have in a child's life to constitute being in regular care of the child. Now, clearly, if you're you see the child sort of half the time, obviously, that's obvious, right? What if you're an alternate weekend? Is that enough? Could be, if it's very regularized, right, and you have some holidays, right? And sometimes, to be frank, at that time, the parent who is the guardian will agree that, you are the guardian of a child, right? Sometimes you get an agreement of that if there's sort of regularized visits and so forth and regularized involvement. And to be frank, the payment of child support generally makes people more open to acknowledging guardianship. So, but again, I didn't find anything new in the guardianship realm, but these are it's still sort of evolving. So you have to, I get then to the informal parenting arrangements next, because it has some interesting implications for guardianship as well. So you know that if there's no order agreement, but you have some sort of regularized schedule going on, or some sort of parenting, that's called an informal parenting arrangement. And under the Family Law Act, you're not supposed to change these informal parenting arrangements without consulting the other guardian. Now, that's why you maybe don't want the person to be a guardian. And unless it's unreasonable or inappropriate in the circumstances. And of course, unreasonable or inappropriate involves things like family violence, or the other guardian isn't around anywhere to be found. or is a member of the Hells Angels and you don't want to talk to them. So this is where you have informal parenting arrangements that what happens there. So there's a couple of new cases a case that came out recently called TPH and BAB, and that's Judge Dulis in provincial court. And if there are no existing orders allocating parenting, then Section 48 of the FLA prohibits any unilateral changes to informal parenting arrangements once they have become part of the child's routine. So that's the key. So it's not just if there is some parenting time going on or some parenting going on, it's really you have established a routine, right? That's what it means in informal arrangement. It's not I visit once a month and maybe I come every third week, maybe I come this day, it's random. It's really about establishing a pattern, a routine for the child. That's when you get into what's called an informal parenting arrangement. In this case by Judge Keyes, the DMM and DF, the evidence was clear that the mom didn't allow the dad to see the child. And therefore, there was no parenting arrangements in place. And the judge found, even though the dad had wanted to see the child and the mom was resistant, that this still didn't establish that there was an informal parenting arrangement requiring her to consult with the dad before changing any such arrangements. So there wasn't a routine that was going to be disrupted. So therefore, there was no informal parenting arrangement. And why was this important? Because the mom wanted to move, right? And because there was no informal parenting arrangement, there was no need to consult with anyone, the father, and no need to get his permission or, have him stop from moving, and she moved. The dad tried to have the mom move back to Prince George from Kelowna, and the mom was successful in defeating that claim. And part of it, to be quite frank, was there was a fairly long history of family violence. And even then, when the father, at the end of this trial, only received supervised parenting time. So apart from the fact there wasn't no informal arrangement, she could go. The application to bring her back wasn't successful, and because of these other factors. But that's a key one for your clients to know, is that if you don't have a routine in place, there is no informal parenting arrangement. You can go. It doesn't mean somebody can't. This is what you come up with. Sometimes my clients say, well, I can just go, right? And I say, you can just go, but your ex may file a application to bring you back, right? And then you have to deal with that. Is it easier to deal with it now and get an order that you can go, or deal with it when you've already moved and have to deal with trying to come back, or dealing with that? So those are things that folks need to think about. One thing that we often don't talk about are the testamentary guardians. And I kind of like this. This is important because this is, you can assign your guardianship, your parental responsibilities, your guardianship rights to somebody else through your will, or if you are terminally ill or maybe close to death, you can also assign temporary guardianship so somebody can take over. It used to be people assumed it was automatic that if you passed away, the surviving guardian would be the guardian. Well, that's no longer the case under the Family Law Act, as you know. And this is an important case that starts off. Judge Dillon talks about how a person who has guardianship rights, and you can only transfer what are your parental responsibilities that you have, right? So if you have none, naming somebody as a guardian to take your place just gives them some standing in order to make a claim perhaps for the parental responsibilities after your death. But ultimately it all comes down to the best interest, right? So they'll succeed or not. If there's no best interest, they won't succeed, I mean. So in this case, the court just clarifies how you can use this testamentary guardian provision, which is that you don't need consent of the other guardian. You can just name somebody in your will, and there's no basis for the other guardian to contest that. You do have to get the consent of the person you're appointing. You should check around, ask your friends, am I in your will? Do I have to take care of your snivelly kids? Anyway, so he could also do his own. And everything has to be in the best interest of the child, right? So ultimately, it's an important provision that I think more and more people should use if you want to have a bit more control. Most people don't. How many people have a will, first of all? So most of us don't. Yeah. And then lots of people don't want to think of dying before your kids die, or dying sooner than when your kids grow up. So lots of people don't think about it. But it's an important, particularly if you have a very difficult ex that you're dealing with, it's important to put these things in place.